Good afternoon, everyone. It's great to see so many familiar faces in the list and pictures of participants. So to start off, I would say that for most of the 20th century, the test applied by common law courts for arbitrator bias stemmed from the famous 1924 dictum of Lord Heward in R v Sussex Justices, that justice should not only be done, but manifestly and undoubtedly be seen to be done. Following this premise, common law courts around the world took a very narrow view of arbitrator conflicts of interest and imposed a very low bar for challenging an arbitrator. For example, in Canada, the Supreme Court of Canada in 1955 stated that it is sufficient for a challenge if there is a reasonable apprehension of bias. Now, in my short talk today, I'm not going to give you the citations or even some of the names of the cases I'm referring to, but I will be happy to provide you with those cases and the citations in the event that you would like them, and you can obtain them by just emailing me at msmith@smithbarristers.com. Now, the long-standing test, at least in Commonwealth countries, was that a mere suspicion or possibility was enough to disqualify an arbitrator, and any person, and for that matter, for any person exercising a judicial function. In England, under the Arbitration Act 1950 and the Arbitration Act 1979, the courts applied a reasonable suspicion test. In the United States, the Supreme Court, in the famous Commonwealth Codings case from 1968, held that a challenge would be allowed where there is an impression of possible bias. The Federal Arbitration Act in the United States requires that an arbitrator be free from evident partiality or bias. Now, as can be seen from these examples, the bar for arbitrator impartiality and independence is set by the law of the place where the arbitration takes place, usually the Arbitration Act in the seat of the arbitration, which is we call the lex arbitri. Now, the test derives from the requirements for impartiality and independence that are set out in the applicable arbitration statute, along with judicial interpretations of those provisions. However, over time, those judicial interpretations have become much more strict. England led the way in this evolution in the decision in 1993 in R v Goff, in which the House of Lords moved away from a test based on mere suspicion or reasonable suspicion and laid down a test requiring a real danger of bias. And that's, I think, a dramatic shift from a possibility or a suspicion to a danger. This was a seminal moment because the bar was dramatically raised for what must be proved to establish an apprehension of bias. Now, the decision in Goff, R v Goff, was made in respect of the test for judicial bias, that is to challenge a judge, but the same test was said in a case called Laker Airways and FLS Aerospace. The same test was said to be reflected in Section 24 of the English Arbitration Act of 1996, which imposes a duty upon arbitrators to act impartially, subject to removal if circumstances exist which give rise to justifiable doubts as to impartiality. I'll just pause there to say that that is the same test that would be applicable under the Unstrel model law. Likewise, an award would be set aside under Section 68 of the 1996 English Act, where the tribunal failed to comply with the duty to act impartially. Now, the Goff real danger test was applied in an arbitration context by the English Court of Appeal in AT&T v Saudi Cable, and that was in the year 2000. Lord Justice May ruled that the test under English law for apparent bias in an arbitrator is the same as for all those who make judicial decisions, as found in the opinion of Lord Goff in R v Goff. Different spellings. The AT&T v Saudi Cable case involved a Canadian arbitrator sitting on a case in England involving alleged misconduct in failing to disclose a directorship in Nortel, a Canadian telecommunications company that had a connection to the respondent in the arbitration. The decision was made under the English Arbitration Act 1950, that was operative at the time of the arbitration, even though the decision came down in the year 2000 after the enactment of the 1996 Act. Now, the real danger test was cemented in English law in the 1999 decision of the Master of the Rolls in the Locobale case, which I'm sure many of you are familiar with, in which it was said that whatever the merits of the competing tests of a reasonable suspicion or apprehension of bias as opposed to a real danger or a likelihood of bias, the law is well settled in England by the decision of the House of Lords in R.V. Goff that it is a real danger test. So much for the decision of the Master of Rolls, because in a dramatic turnaround, soon after AT&T and Saudi Cable, the House of Lords in Porter and McGill in 2001 reverted to a real possibility test rather than the real danger test. The apparent reason for the reversal was the need to align the test for bias in England with that adopted by the European Court of Human Rights. The House of Lords noted that the Goff test has not commanded universal approval, that's a quote, and that circumstances for challenge must be such as would lead a fair-minded and informed observer to conclude that there was a real possibility that the tribunal was biased. And the court took some pains to eschew the language of the real danger test. So at the time Porter and McGill was decided, the English courts were required to take into account the jurisprudence from the European Court of Human Rights, but that obligation no longer exists. And so what is the current approach of the English courts? Well, we're going to find out soon, because the case of Halliburton and Chubb Insurance, which some of you may also be familiar with, was argued in November of 2019, and the decision of the UK Supreme Court is imminent and could come down any day. Now, the Halliburton case involved a highly respected arbitrator from London Chambers who failed to disclose involvement in a number of arbitrations in which Chubb was a party when he was sitting on a case involving Halliburton and Chubb arising out of the Deepwater Horizon catastrophe. The English Court of Appeal in Halliburton was called upon to decide an application to set aside an award on the basis of the common law test for bias under Section 24 of the 1996 Act. The test applied was the real possibility test, that is, the Porter and McGill test, not the Goff real danger test. The Court of Appeal agreed that the mere fact that an arbitrator accepts appointments in multiple references concerning the same or overlapping subject matter with only one common party does not of itself give rise to an appearance of bias. Something more would be required, they said. The court went on to say in the Halliburton case that the arbitrator ought to have made the disclosure of the other appointments, but the court ruled that in the circumstances, the accidental failure to make that disclosure did not give rise to justifiable doubts as to impartiality. There was not, therefore, a basis to conclude that there was a real possibility of bias. It remains to be seen whether this conclusion is confirmed by the UK Supreme Court in Halliburton. The interesting issue to watch for is whether or not the Supreme Court, again, will revert to the Goff real danger test now that it is no longer bound by English or European law jurisprudence. So it's interesting. This was the second time the higher courts in England had excused a failure of disclosure, notwithstanding legal duty of disclosure. Now, arbitral awards were allowed to stand in those two cases in circumstances where the arbitrators might have been disqualified if the failure to disclose had been discovered much earlier on in the reference. So it may be that in practical terms, and I'm just speculating here, it may be that in practical terms, once an award has been made, you may have to actually show actual bias in order to get it set aside. Or in those two cases, Halliburton and AT&T, the two arbitrators involved were extremely experienced, were very well respected, and it may be that just hard facts make bad law. So it's interesting to compare the Halliburton case to this decision of the Privy Council in Al-Mazidi and Penner and another, a case that came out of the Caymans. Now, the trial judge in Al-Mazidi was challenged on the basis that he had an undisclosed, albeit tenuous, connection to one of the parties. Sir Peter Cresswell, a highly respected English commercial court judge sitting in the Caymans, failed to disclose that he had been appointed as a supplementary judge at the Qatar International Court and Dispute Resolution Center. He'd never sat in that capacity and never earned any money from the Qatar appointment, but there was a remote connection between the claimant and a Mr. Kamal, who, as Minister of Finance in Qatar, could have influenced the reappointment of Sir Peter to the Qatar court 5 years hence. The Privy Council held that it was wrong to not have made the disclosure, and this represented a flaw in Sir Peter's apparent independence. It seems that this decision by members of this UK Supreme Court, sitting as the Privy Council, is at direct odds with the decision in Halliburton. Both were applying a real possibility test. Again, it will be interesting to see what the Supreme Court, the same judges, decide in Halliburton, but I would predict that the court will not find any apprehension of bias in the arbitrator from London Chambers, notwithstanding Al-Mazidi, and whether or not the Supreme Court reverts to the real danger test. Meanwhile, back at the ranch, the government of British Columbia recently amended both the Domestic Arbitration Act and the International Arbitration Act to impose a statutory requirement for a real danger test. The Attorney General, when introducing the amendment, stated that the intention was to raise the standard needed for a party to challenge an arbitrator's independence or impartiality. He noted an international trend toward a higher standard because of a concern that challenges with little merit were being employed as a strategic tool to disrupt arbitrations. Now, this international trend that was mentioned by the Attorney General included the amendment of the Australian International Arbitration Act in 2010 to impose a statutory real danger test. The amendment of this, the Australian statute has been termed the Goff Amendment, referring, of course, back to the House of Lords case from 1993. In addition, as I mentioned earlier, in the AT&T and Saudi cable case, the real danger test was applied in an arbitration context. So the amendments to the British Columbia legislation are consistent with an international trend and also with a local trend in the sense that the courts in Canada have evolved their test or their interpretation of the test required for a reasonable apprehension of bias, whereas it was once in Canada, again, the real suspicion or the reasonable apprehension test. The Supreme Court of Canada in 2015 moved the bar up to what is called a real likelihood test. And their basis or premise for doing so was a stated strong presumption of impartiality applicable to judicial officials. So there's a question as to whether or not that presumption would be applicable to a consensual commercial arbitrator, because one would think that the parties to an arbitration are entitled to a subjective, sustained sense of confidence in their appointment or who is sitting on their case, and why should they have to overcome some artificial presumption that is created out of whole cloth by the courts? Still remains to be seen. Now, the situation in the United States has not evolved to the same extent as in Commonwealth countries. The possible bias test from the Supreme Court in Commonwealth codings in 1978 is still the evident partiality rule. But the United States offers some interesting examples of bias, and I'll just elaborate just shortly on that because my time is drawing short. One colorful example is the case of La Serena Properties in Weisbach, where Mr. Weisbach had his award set aside because he failed to disclose that he was dating the sister of the lawyer for the claimant in the arbitration. It's interesting that in a civil claim against Mr. Weisbach, based on the intentional non-disclosure of the relationship with the sister, the California Court of Appeal held that the arbitrator was protected by common law arbitral immunity for quasi-judicial acts because the conflict of interest requirement was an integral part of the arbitration process. To be discussed whether that same immunity would extend in Commonwealth countries, subject to whether the 1950 English Act or the more modern statutes, including the Unstrel model law. Another interesting decision from the United States, very recent, 2020, involved a JAMS arbitrator who failed to disclose that he had, that the claimant in that case, Monster Energy, in a case called Monster Energy and City Beverages, failed to disclose that JAMS had administered some 81 arbitrations involving Monster. Now, it so happens that JAMS arbitrators own a piece of the rock, and they have a financial interest in the economic success of JAMS. And the United States Court of Appeals for the Ninth Circuit in 2020 held that that history of Monster Energy with JAMS should have been disclosed. Finally, I'll just say that there's another case in a case called another 2020 case, Meyer and Uber Technologies, where the arbitrator remarked, "I must say I act out of fear. My fear is if I ruled Uber illegal, I would need security. I wouldn't be able to walk the street at night. People would be after me." The unhappy party also alleged that the arbitrator was starstruck by the principal of Uber, Mr. Kalanick, claiming that the arbitrator used his smartphone to photograph Mr. Kalanick after his testimony. The court ruled that the arbitrator's remark about acting out of fear was simply an attempt at humor, and that the remarks were not consistent with impartiality or a lack of impartiality once their patently justful intent was recognized. The hero worship allegation was considered to be mere speculation. So I'm coming to the end now. I think I've got a couple minutes left. The French Code of Civil Procedure provides that an arbitrator is obliged to disclose any circumstance that might affect independence or impartiality. In a recent decision of the International Chamber of the Paris Court, a commercial chamber, a challenge was made to a party-appointed arbitrator on the basis that the arbitrator had a relationship with the law firm regularly representing the parent corporation of the claimant in that case. There was no disclosure of that connection. The court concluded that undisclosed conflicts must create a reasonable doubt. That was their test, a reasonable doubt test, as to a lack of independence, and that notwithstanding that the conflicts should have been disclosed, the arbitrator said that he wasn't aware of the conflict, and the court excused him. I'm going to mention one final case, which is of interest because it came out of the Barbados. It was a result under French law where the award was sought to be enforced. And that case was 2016 Caribbean Fiber Holdings and AGI. It involved a Canadian arbitrator sitting in the Barbados under Barbadian law in an ICDR case. The award of the arbitrator was set aside because of a failure to disclose a connection between the arbitrator's law firm and one of the parties. The claimant was a wholly owned subsidiary of a corporation that was represented by the Toronto office of the arbitrator's national law firm in a $500 million sale of mining interests. The arbitrator was completely unaware of the conflict, and indeed had made a conflict search that came back negative. The Toronto lawyers had failed to disclose that representation of the parent of the claimant company to the arbitrator. Nevertheless, the French court held that the failure to disclose the conflict was such as to reasonably cause a doubt regarding the independence and impartiality of the arbitrator. So it can be seen from these results that the reasonable doubt test for arbitrator bias in France can lead to wildly different results. And likewise, you can see wildly different results in cases that follow the English examples and the American examples. So really, when looking at challenges for bias, any result can happen because the tests are so loosely interpreted. Those are my comments. Thank you. And I pass it back to you, Shan. Thanks very much.